All right. Welcome, everyone, to Ditch Diggers Dialogue, Volume 33. My name is Ashley Hudson. I'm the Director of Member Engagement for the Heavy Construction Contractors Association, and I welcome you all to today's webinar. Joining us today is Jonathan Wright, partner at Watt, Teeter, Hoffar Fitzgerald LLP, who in his role represents owners, prime contractors, subcontractors, and sureties on construction projects. He has successfully guided his clients through challenging legal issues involving default terminations, design defects, payment disputes, indemnification, differing site conditions, delay claims, and inefficiency/lost productivity claims. During today's session, we ask that you keep your microphones muted until we open the floor for questions. And if you have questions or thoughts throughout the presentation, I encourage you to type them in the chat box as we go so they can be addressed at the end of the presentation.
I'm gonna have to take it on mute. Genius.
All right, Jonathan, the floor is yours.
Excellent. Well, thank you, Ashley. I appreciate that. Good morning, everyone. And thank you for having me today. Again, as Ashley said, I'm Jonathan Wright. I'm a partner with Watt, Teeter, Hoffar Fitzgerald, and my practice is focused almost entirely on construction claims and disputes. We often see claims that are legitimate at their core, but they fail or are significantly reduced because of how they're handled early on. And what I want to talk about today is claim preservation, but not just really in the technical legal sense. It's really about how contractors and project teams can protect their contractual rights without damaging their client relationships, reputations, or future work opportunities. In my experience, you so often see contractors or subcontractors let claims expire because they don't want to anger the owner or the prime contractor. In doing so, they can let claims, sometimes worth millions of dollars, expire. And this is especially important here in Virginia, where courts strictly enforce notice and claim deadlines. I'm here today to tell you that you can do both. Preserve your claims and preserve your client relationships, whether you're a subcontractor or a prime contractor. So I'll talk a little bit about what this presentation is and what it's not. It's not a litigation seminar. I'm not here to tell you how to sue your clients, and I'm not here to encourage disputes. This presentation really is about practical claims management, how issues arise on real projects, how they turn into claims, and how those claims can be handled in a way that preserves both your contractual rights and business relationships. So we're going to start by talking about the different types of claims that arise most frequently in construction and why they matter so much. From there, we'll talk about contracts, because whether people like it or not, contracts quietly decide most claims long before anyone argues about fairness or fault. We'll spend time on best practices for notice and documentation, because those are the two areas where I see the most avoidable claim failures, not because the contractors were wrong, but because they didn't follow the contract. And after that, we'll talk about preparing and negotiating claims. And this is where the legal rights and business realities really intersect. You can be right and still lose if the claims are presented poorly. And finally, we'll close with a few prevention strategies. How do you make your claim so well documented that the owner or prime contractor pays the claim without needing to go to litigation? And that's the gold standard. That's what we're hoping you guys get from this. How to present those great claims without having to spend the extra money and take the risk in litigation. All right. But this slide really talks about the theme. It's a balancing act, right? How does one interact with your client, whether it's an owner or a prime contractor, either one. On the one side of the scale, you have your legal rights, and those are your negotiated, priced, and relied on terms when you sign the contract. Those are like time extensions, additional compensation, and relief from owner cause impacts. On the other side, you've got your business relationships, whether it's owners, developers, GCs, and in general, just repeat clients, trying to keep people coming back to you. And that's what keeps your repeat business. That's what keeps you in business, is having people who want to work with you and know that you do a great job. So I see contractors waive valid claims because they're trying to be good partners. You see this all the time. Just remember, the owner or the contractor gave you the contract to sign. And when you submit claims or you provide notices, you're just being diligent in submitting these claims according to those documents. And I see contractors damage relationships because they assert claims late or assert their claims emotionally or in such a way that feels like a surprise. And really, none of that works. You get unresolved claims disrupt cash flow and erode margins, and oftentimes will force a contractor to carry a financial burden that feels like you're almost financing the completion of some of these projects. And at the same time, poorly handled claims can escalate tensions and turn manageable issues that were, if they were done right, could lead into litigation. So the point of what I want you to take away from this is professional claim management doesn't have to be adversarial. All right. Professional claim management is just a part of project management. So when things are identified early, documented properly, communicated professionally, they often integrate seamlessly into the project. Hopefully, if you do it the right way, you get a change order, time extension, or some negotiated resolution. But when the claims are ignored or delayed, put off, and worse, handled emotionally, usually at the end of the project, that's when people's positions get most entrenched, and it's really hard to come to an agreement on how to resolve a claim. So you want to stay on the right side of that balance, submit timely, write clearly and professionally, and avoid too much emotion. One of the things I want to talk about is I want to contrast the contractor's perspective on claims and then we'll say the owner's perspective on claims. Why do these things matter, right? From a contractor's perspective, claims are about survival. You have put out the money. You guys have your people toiling on the project and you are paying them, all right? These claims affect your profit margins, whether you're going to be able to, pay your employees a bonus this year, your bonding capacity, and future work, right? When you delay your claims, not only do you wind up damaging a client relationship, but you often wind up pushing down the road and carrying that cost further and further, rather than dealing with it up front, like the contract might require you to. I hear this all the time. I don't need to submit the notice now. The owner has known about this for weeks. It's in the meeting minutes. I can't tell you when I say, all right, does the owner know about this? Have you given the notice? They're like, oh, it's in the meeting minutes. All right. Well, that almost never is going to carry the day. I tell you, if let's say the contract says this, the contractor must submit a notice within 5 days of the event giving rise to the claim, and the claim must be substantiated with a time impact analysis and damages claim back up within 10 days thereafter. In Virginia, if you don't strictly comply with the contract, you're out of luck. I really don't care if it's in the meeting minutes, and neither is a judge or an arbitrator. Okay, you've got to send that written notice, even if you're in the middle of negotiations, but it doesn't mean that your tone has to be adversarial, right? It can be plain and matter of fact. Let me give you an example. I'll read what I think would be a very, middle of the road, non-emotional way to trigger your contract rights without being over the top. All right. As we previously discussed, and in accordance with Article 7.6 of the party's contract, contractor hereby submits its notice of a differing site condition caused by subsurface conditions that differ materially from the subsurface conditions referenced in the geotechnical report. In accordance with Article 7.7, contractor is presently developing its TIA and gathering its cost documentation, which will be submitted within 10 days of this notice. As this issue is ongoing and contractors' delays and cost impacts are continuing to accrue, contractor reserves all rights to supplement its notice and claim documentation as may be necessary from time to time. Contractor reserves all rights under the contract and applicable law. You don't have to get into it. You don't have to get into the emotion of any part of a claim. What you've done there is exactly what you need to do. You trigger the contract, you tell them what kind of claim it is, all right? You give like a short explanation of what's going on. And then you also let them know, I've read the contract. I know what's going to happen in 10 days. I know I've got to give you my TIA and my costs back up, right? But almost at no time are are claims and issues resolved within 10 days. So it's not like you're going to know everything within 10 days. So make sure you're reserving your rights at the end there. And again, this is something that even if it's a contentious issue, when you put it in writing in a neutral manner, it's going to serve you much, much better going forward. There are hidden tolls of unresolved claims, and a lot of times people don't think about these types of things, right? When if a claim is not timely asserted, it can really stress the client relationship, and it can be difficult to repair because an owner will receive it, will say it's untimely. The contractor gets upset. He says, "You've known this for a long time. You've said it has merit, Mr. Owner. Why won't you pay me?" Right? So when done at the wrong time, it can raise a dispute. It can brand a contractor as difficult, uncooperative, or high maintenance. And that reputation can close doors to future work, even if no one ever says it explicitly to your face. There's also a management toll on the part of the contractor. Old claims consume enormous amounts of executive project management time. Leadership attention gets pulled away from current projects and business development and operational improvements and redirected instead toward recreating the history of this claim and managing a conflict. Okay. I've seen owners, project managers, and executives spend hundreds of hours reconstructing events that could have been resolved with early notice, early documentation. That time has a real cost to construction companies, even if it never shows up as a line item. When you're trying to repackage claims months later, you're not paying attention to your current projects. And everybody I know here is super busy, and trying to go back and redo this is going to take time away from your family, take away your free time and things like that. You also have a problem with internal morale. You have the snowball effect of recreating an old claim that has expired, on top of actively managing the project, on top of giving your notice for current claims, on top of talking to management, on top of talking to attorneys and experts. And that will drain the morale of even the most senior project executives. And of course, I think one of the most obvious things is unresolved claims create business instability. Cash flow strains can affect payroll, bonding, and relationships, and all this is avoidable. So it's not about being aggressive. Again, it's about being timely, disciplined, and professional. And when they're addressed early and transparently, they're far less likely to escalate into disputes. But put yourself in the shoes of your client, whether whether your client is an owner or a prime contractor. There's several reasons why they would be resistant to receiving claims. First, claims threaten budgets. Almost every project is approved with tight financial assumption, and unplanned costs can raise internal red flags long before anyone even considers entitlement. An owner doesn't want its citizens to pay more if it's a municipality or a state government, and a prime contractor doesn't want to have to pay a subcontractor for money it's never going to get from the owner. Okay. Claims disrupt schedules. Even when a claim is purely financial, granting a claim, an owner could worry that acknowledging it will open the door for time extensions or other delay arguments, etc. Okay. There's also the increased administrative burden, more meetings, more documentation, more internal reporting. Maybe you have to get outside counsel involved. Maybe you have to get an outside expert involved. All of those things are burdensome, right, to an owner or a prime on this issue. And of course, claims create reputational risk for owner representatives. Claims imply that something went wrong under their watch, and that reality shapes how claims are received. Owners have bosses, lenders, politicians, boards of directors, and other bureaucrats that they give progress updates to on a regular basis. Receiving a late claim, especially a substantial late claim, makes the owners look to their bosses like they don't know what they're doing. All right. So the best practice is don't wait to the last minute. There may be contract provisions or statutes that require initiation of litigation within a statutory time period. Do not wait to the last moment to file litigation. If an owner is a public entity in Virginia under the Virginia Public Procurement Act, a contracting officer doesn't have the authority to extend the statutory litigation deadline. It's jurisdictional. If you miss that time frame, your claim will be void if you do not initiate litigation within the proper time. And if you're a sub and you're passing through a claim to a prime contractor, give plenty of time to the prime to make an election about how it will pass your claim through. You don't want to appear as if you're ambushing the prime contractor just before the statutory litigation commencement period or commencement deadline passes. Doing so is a great way to damage a relationship and threaten an otherwise valid claim. Claims that ignore these pressures tend to feel adversarial from the outset, and that's what I'm telling you. Put yourself in your client's shoes. If you were the client and you had these different pressures, how would you want to receive the claim? So submit it timely in accordance with the contract and in a professional manner. You may even consider giving the recipient a courtesy call just before it lands on their desk. Let them know you're just trying to protect your rights. Follow the contract that you asked them to follow. It's far better to assert a timely claim than to ambush an owner or prime contractor with a late claim. When one does come late and out of the blue, it puts undue pressure on the owner that is certain to harm your reputation and your chance of getting the claim paid and probably of getting future work. So these are 6 common types of construction claims, and they're highly predictable. I know you guys have all seen these before, but what I do want to do is go through these things and talk about some of their more interesting characteristics and why you need to treat each of them differently. First, differing site conditions. Many contracts require a contractor to give notice before the condition is disturbed. If the contractor ignores it and proceeds, an otherwise viable differing site condition claim can be waived. The second category is labor and material escalation. These claims have been far more common in recent years. Depending on how your contract is written, these costs may or may not be recoverable, but prudent contractors or subcontractors will attempt to negotiate risk-sharing provisions for price escalation, especially in the post-COVID and current tariff era. Additional or extra work claims. These are probably the most familiar to everyone on this call, but the pitfall is that often a contractor will recognize a problem or orally negotiate it for a few weeks. Then the negotiations fail. All right. Then a notice is submitted, but the notice is required to be sent in writing within 3 days of the event giving rise to the claim. Here, a contractor has unwittingly walked into a claim waiver issue because he didn't take the 30 minutes to send a notice as required by the contract, right? You know, one of the things you got to think about in contract administration is don't roll the ball uphill. Don't make it more difficult for yourself. A late claim automatically has a reduced value. You put your $1 million claim in late. Do you think the owner and the prime is going to be negotiating with you off the full value of that claim? The first thing they're going to say is, first of all, your claim is late. It has no value whatsoever, and you've waived it. But we'll negotiate with you later, maybe just to make you go away. Don't miss deadlines and don't compromise your own claim before it goes in. These things really are, and we'll talk about this theme throughout, these submissions and notices are dollars. And you've got to remember that. They're not just headaches. They're things that you have to do, and they have value. All right. On to number 4, delay claims. Very often a prime contractor subcontract will require the contractor or subcontractor, as it may be, to submit a time impact analysis showing how the critical path of the project will be affected by a particular change. But all too often, contractors without the requisite experience attempt to do this on their own, or they skip it altogether, suggesting the delays are self-evident. Everyone was out there, everyone saw it, everyone knew that the concrete trucks couldn't reach the project site because of whatever reason, right? This is a great way to have your claim rejected because you failed to meet the substantiation requirements of the subcontract or the prime contract. And for the subcontractors out there, don't forget, your rights generally are going to also be affected by the prime contract, which is going to flow down through your subcontract. So if you are a subcontractor on a project and you don't have a copy of the prime contract, go out and get it, because you have to read those two contracts together to figure out how your rights flow. There are plenty of subcontracts I've seen out there that says any notice provisions or any notices must be given within half the time required by the prime contract so that the prime can review the claim before it submits it. All right. How are you going to know how much time you have if you don't read the prime contract? You've got to know it. Don't let that go by. Don't wait until you have a claim and you're seemingly adverse to the prime contractor and you're asking, oh, can I please have the prime contract now? Get it up and early. I wouldn't even sign a subcontract if you haven't read the prime contract. You've got to know how those things go together, but you'd be surprised how many subcontractors don't read terms and conditions, general conditions that are flowed all the way down before signing their own subcontract. The fifth category, owner-related changes. So these are obvious changes. Most of these are bilateral. It comes on a formal thing called change order, right? But the trick here arises when a contractor signs a change order for time and or money that doesn't fully compensate them. In other words, the impact was recently sustained. You think you might have, put in all of your costs, but you're not sure the claim's really still ongoing, right? But most change orders or contracts will state that if the contractor accepts the change, it waives any subsequent claims for additional time and compensation for that issue. So unless the owner is willing to carve out express language reserving the right to make subsequent claims arising from the issue, and the contract doesn't contain waiver language, a contractor is often better off not signing a change order for which he's not fully compensated. You will wind up waiving subsequent delays, impacts on other work, inefficiencies, delays to equipment or material affected by that change that could not have been anticipated at the time of signing. And then you've got tariff and regulatory impacts. This is really hot right now over the last year because, what President Trump has been doing with the tariffs. At first, there were huge tariffs, and then they were lowered, and then they were taken off, and then there was a pause, and then they were put back on. And then a couple of days ago, the Supreme Court says they're invalid. All of these things have real world impacts, especially if anybody is buying equipment from overseas for use on a project here. Let's say you're buying something from Europe with a 30% tariff, or China with 150% tariff on it. I mean, that can really materially impact your bottom line. Most contractors now are trying to negotiate these types of clauses for price increases as a result of tariffs that really nobody can foresee. It's a risk sharing mechanism that I would encourage everyone to do. If you're not doing that, or if you're negotiating with a government entity that just basically tells you to pound sand and won't do anything like that, then you really need to evaluate your risk and see, what could the impact to you be. All right. So another takeaway, I would say, many of these claims have different notice periods, and many of the claims could technically trigger more than one type of claim. For example, is a claim for a differing site condition, is the claim for a differing site condition, or is your claim for defective contract document that misidentified the subsurface conditions? I mean, it really could be both in many cases. And a good rule of thumb is to give notice on the shortest possible deadline, reserve your right to supplement the claim, and do so periodically as you continue to accrue those costs. So, getting ahead of the game, how do you do this? How do you make sure you're set up for success? Well, I would say this: claims management really starts on day one, not the day that you that you need to send your first notice or you sustain your first impact. Companies, contractors and subs, they need to have a dedicated project management team whose responsibility it is to know the contract and follow it. Project executives must set expectations around scope, communication, and claims procedures. This includes defining how changes will be handled, how notice will be given, and how documentation will be maintained, there needs to be, and I think this is the most important, you need to have a point person who takes responsibility for giving notice and substantiating the claim. As I said before, each one of these letters and notices is money. It's cash value, getting him in on time. And the problem is if you have, 3 or 4 people who are kind of in charge with it rather than one person, they each pass the buck. And that's what you can't have. You can't have several outfielders trying to catch a fly ball and no one calls it. You've got to have the leader. You've got to have the center fielder that says it's mine and takes the ball and runs with it. And that's the way things won't fall through the cracks. And if your project management team is too understaffed to manage this, I understand that. Reach out to an outside counsel you trust. I oftentimes make project books for clients that lay out flow charts of how the notice and claim provisions work. I will prepare form notice letters for all the different kinds of issues. I'm also on call whenever a client needs me to assist on the project. And I know it sounds counterintuitive, but getting an outside counsel involved on a project early saves construction companies money. It prevents ramp-up costs on a project, and the attorney can stay abreast of issues as they develop, rather than trying to read thousands of pages of documentations a few days before a claim is due. The other recommendation is to find an outside damages and scheduling consultant that you trust if you don't have an in-house team capable of complex scheduling, damages quantification, and time impact analyses. It is almost a general rule that all claims are more persuasive to an owner if a contractor engages a qualified expert that will place their imprimatur of legitimacy on the claim, rather than submitting one that's in-house where it could be looked at as obviously one-sided or unrealistic in terms of schedule or damages analysis. The problem is when you submit those obviously one-sided claims that are probably overstated or unrealistic, your claim lose legitimacy right out the bat. Not as your claim lose legitimacy, your company loses legitimacy in front of your client. So you're doing yourself double harm. You're hurting your reputation and you're not doing anything to really move your claim forward. So let's talk about contracts, the contract mastery, right? Contracts govern claims. Whether you like it or not, that's going to be the first thing that judges and arbitrators are going to look at. And often the last. Sometimes a claim doesn't even get to the merits if a lot of precursor events or conditions precedent didn't even happen. And that's your contract is going to govern that. So notice provisions, claim procedures, time extension clauses, and compensation language quietly decide the outcome long before anyone debates who's at fault and who's got entitlement. One of the most dangerous assumptions I hear is that everyone knows what happened, so the contract won't matter. I'm telling you, it always matters. You want to write every claim notice letter like a judge will pick up the letter 3 years from now with no context about the claim, so that each letter is self-contained and properly references any other document specifically. So contract mastery doesn't mean memorizing every clause. It just means knowing where the risk provisions are in your contract, frequently returning to it, and making sure the project team understands the provisions that affect time and money. All right, key contract clauses, best practices. And I'm going to beat this notice issue like a dead horse because it's so important and everyone misses it. Notice. These clauses are going to tell you when notice must be given, how it must be delivered, to whom it must be addressed. Many contracts explicitly state that waiver or the failure to comply results in waiver, and these provisions are going to be enforced. Strict compliance beats good intentions. It's another takeaway I want you to hear from this slide. But it's not just about if notice was sent before the deadline. Sometimes notices must be received by a deadline. In some contracts, notice cannot be given by email. It must be sent by certified mail or FedEx. You've got to follow that. Otherwise, you're just giving an argument to the other side. You've just chipped away a couple percentage points at your claim, right? Some contracts stipulate when notice is deemed received, i.e. 3 days after mailing. Each of these requirements are critical. So if you go to send your claim in, it's due the next day, you send it by certified mail, okay? 3 days and it's deemed received, all right? Sorry, guy, your claim is late because you didn't read, all right? So think about that. I almost never send anything certified mail because the mail is simply unreliable. I've sent things certified mail because I had to, and they never reach the recipient ever. And you don't know until weeks later. Spend the 25 or 30 bucks, send it FedEx, get a signature on it, and then that way you know it was actually received by the person it was supposed to be sent to. And who was supposed to receive it? Contracts are often going to designate point persons for the receipt of claims and other notices. If it's the contracting officer and you send it to the contracting officer's engineer because you deal with him more, is that satisfactory? No. You just chipped away another couple percentages off of your claim because they're going to say, well, our engineer got it, but he didn't send it to us and we didn't really see it till much later. We don't think you followed the contract. It's just stacking that doesn't need to happen on your claim, right? If the contract says you must send your notice to a vice president in Omaha and you email the PM on the project site, does that count as notice? Nope, it doesn't, all right? So other notice provisions have strict content requirements. So even if you fail to meet those content requirements, your notice will fail even if it's timely sent. For instance, if it's telling you include cost backup, a narrative, a TIA, and you don't put that in there, that's on you. You probably, again, chipped away another significant amount of value away from your claim. So again, designate that point person who writes the notices, make sure they can write well and make them send the notices. If not, you might have to call your attorney and send them the documents, tell them to pump out a notice letter ASAP, because it's better than letting a claim expire or be compromised because of a lack of notice. This slide groups together several clauses that also significantly shape claim outcomes. I know that a lot of this stuff you're going to say, oh, I've seen this before, but I want to pick out a couple of unique provisions that maybe are not on your radar that I do think you really need to consider. So obviously with time limits and deadlines, notice, claim submission, response times, that's fine. But a lot of times what people forget are deemed denied provisions or statutes, right? So often a contract will state that if a claim is submitted and not responded to by the owner in a certain time, the claim is deemed denied. So your submission of your initial claim can often commence a silent time period where your claim can be waived if you do not take it to the next level in writing. That could be, taking it to dispute resolution. The next step, it could be, a contractual thing. It could be filing litigation, whatever the case may be. But your project team needs to know ahead of time what the next step is. Calendar the date. Include on that calendar everyone on your project team so that everyone knows when that date is. Be on top of things and you won't miss them, right? Dispute resolution, this will dictate the path forward. Negotiation, mediation, arbitration, or litigation. These provisions affect cost, leverage, and strategy, and they influence how claims will be prepared and presented. We'll talk more about ADR towards the very end, and why some of them are more favorable to others depending on the type of dispute that you have. When you get down to it, what is everyone out there on a contract, on a construction project trying to do? You're trying to build your project, trying to get paid, okay? And there are very often compensation clauses dictating how the claims must be priced. Some contracts require actual costs. Some limit overhead and profit. Some may require specific documentation as a condition precedent of payment. Meanwhile, owners want to force contractors to price their claims according to the bid or the schedule of values. You should be aware of these pricing clauses before you sign the contract. When you do submit a claim, you want to submit it with the required backup in accordance with the methodology required by the contract, and be prepared for pushback from the owner if you don't. Okay. And we see this very often about how certain labor prices must be priced depending on like if you're working on a federal contract or so forth. One of the best practices that I strongly recommend is to create a one-page contract summary at the start of every project. You can either do it in-house or you can have your outside counsel do it. I'd recommend having your outside counsel do it just because you want to make sure they've read everything. But it would list notice deadlines, required recipients, claim submission deadlines, pricing rules, etc. So this one document alone, if people are familiar with it and they're watching it, can help prevent claim failures more than almost anything else out there. So, early claim recognition, the path to success. This is something that I've adopted in my own legal practice, and I think it makes sense for contractors and subcontractors as well. Do the work for the contractor or the owner, whoever your claim is going up to. Make it easy for them, right? Make it easy for them to get to yes for you. And one thing that I have said is write for the lazy reader, all right? So when I say that, this is what I mean. The person receiving the notice shouldn't have to reconstruct the facts, search the contract, or guess at what the impacts are, all right? If they have to actually do that work themselves, the likelihood of a delay, denial, or friction regarding your claim increases dramatically. So cite the contract, right? Quote it, don't paraphrase it, all right? If you've got a great email or a great letter or a photograph or something, include it in there, right? Again, your letters and your notice letters and claim letters should read that a judge or arbitrator 3 years down the road can pick it up and understand exactly what you're saying without having to guess and look elsewhere. But all of these notices and claims, they share several characteristics. They're factual. They describe what happened, when it happened, where it happened, without emotion, exaggeration, or blame. Words like unreasonable, reckless, or outrageous, they really don't belong in notices and claim letters unless it's a really, really obvious situation, all right? Tie your letters directly to the contract. Even a short reference is helpful. It signals professionalism and shows that the issue is being handled with the agreed framework in the project. Identify the impacts. Even if those impacts are preliminary, it's perfectly acceptable to say that the full extent is not yet known as long as rights are reserved. Remember, professionalism, I'll repeat that over and over. We see all too often when emotions get high, professionalism goes by the wayside. You can have big personalities in construction, but I'll tell you, as a practitioner who sees these things in litigation and in depositions, that kind of emotion in writing almost never serves the writer very well. So a notice that reads well to an executive audience is more likely to gain traction. Remember, when an owner or a prime contractor receives that written notice, it's going to go to a group of people. They're going to look at it and discuss it, okay? And you want that professional attitude. Another thing, title the notice how the contract tells you to. If you must first send a notice of intent to claim, call your letter notice of intent to claim. Don't call it notice of delay or notice of impact or anything like that. Just do what the contract says, always and exactly. So another thing that's going to make your claim stronger, and like I said, writing for the lazy reader, writing for the audience, you're doing the work for them. By submitting a well-documented claim and notice, you're making it easier on the recipient. By now, they already realize they told you to submit the information and you're doing it, right? So when you start, all of this stuff goes into keeping a good client relationship. It shows professionalism. But documentation without, or a notice without documentation really is often useless, right? Documentation isn't busy work. All of these things, logging, weather, logging, the materials, RFIs, all of these things is evidence creation that's going to help support your claim when the time comes to do it. So they all become part of the project record. When claims are evaluated months or years later, these documents often matter more than anyone's recollection. And I would just emphasize that documentation is almost more important than what someone's going to say on the stand or in a deposition a few years later, because it was contemporaneous. The people don't have the ability to forget things or tweak their memories or whatever. All right. But you got to be consistent, right? Make sure you're doing those things on a regular basis. That helps with trying to maybe call these documents business records, right? If they're regularly kept in the normal course of business, that'll help you with some evidentiary issues. Inconsistent records will just invite skepticism and create opportunities for denial. And be objective, and descriptive. Our crew stood by for 2 hours due to a late material delivery, right? That's going to get you much further than saying, quote, the owner caused unacceptable delays, right? And visual documentation. Everyone says a picture tells 1,000 words, and that is 100% true. Timestamped photos, videos, annotated drawings, all these things are incredibly persuasive, especially when they're tied back into daily logs. Let's see. So the takeaway from this is pretty simple. If it's not documented contemporaneously, then it becomes exponentially harder to prove later, no matter how legit your claim is. I always say if it's not in writing, it didn't happen. And that is 100% true. So let's talk a little bit about technology. I'm going to speed up. We've got a bunch of things to go through, but I want to make sure we touch it all. Technology is great because it can let a small outfit punch way above its weight in terms of being able to put together professional claims. There are many scheduling technologies out there that you should be using or know how to use. Obviously everyone knows about Primavera, P6, but there's SteelRay Project Analyzer, Acumen Fuse, Smart PM, other things like that. Google Earth is great. Let's say you have a situation where your access to the project is impeded, and you have to take a new route, right? The distances used by Google Earth can really be helpful. Digital tracking, time cards, but most importantly, I would say is your cost tracking, being able to segregate your base contract work from impacted work where a claim arises, right? Contractors really get into trouble where they don't segregate their costs, and then you have to pay an expert to come in retrospectively and try to untangle that, all right? And that is very problematic, But then there's other just minor things for professionalism. Don't send letters in Word form. Convert them to a PDF and sign them, or make a DocuSign, right? That's going to make your claim look a lot more professional as well. So preparing the claim document, this is where everything really starts to come together. But it should be robust. It should read like a story, right? What happened? Why does the contract allow for relief? How are time and money impacted? And most importantly, what's your ask? What do you want, right? Again, don't assume that the reader understands the project. That assumption is almost always wrong, especially because you're going to see this claim probably years later down the road in litigation or in a deposition. So presentation matters. We'll talk about things like, headers, detailed event descriptions, contract references, the impact statements. And again, with this claim, use that great documentation that you set up, right, in support of the claim, right? Do that work for your reader, make it easy for the contractor to receive a claim and go, wow, I got this from our sub. It looks really good. I've reviewed it. It looks reasonable. I'm passing it up to the owner, right? The last thing you want to do is get into that back and forth because you didn't, substantiate your claim in the way you really were supposed to. So again, we're kind of coming, towards the end, but I would say this, think about everything you write on the project as if you're going to see it again. Don't use foul language. One of my favorite things in discovery is finding where somebody is using really foul language against somebody else, bringing it out in a deposition or at trial, surprising them, putting them on the spot, right? And just using verbose language that's really not helpful, reckless, irresponsible, and things like that. Because the person about whom you're writing can very, very likely is eventually going to get wind of that. And if you were talking about someone at your client, that's going to have an impact on your future business. So always keep it professional, and so forth. All right. Emotional correspondence almost always hurts claims. I want to talk quickly about damages, because damages are so important. You can have the best claim in the world, but if you can't tie your damages to the impact, you get $1. It's called nominal damages. Entitlement's not enough. The gold standard of what you want to do is the actual cost method. You want to be able to use that cost accounting software with cost codes to track your actual costs for the changed work or impacted work. Track your labor hours, equipment usage, material invoices, with different cost codes from your base contract work. Now, yeah, it requires discipline, right? But once costs are commingled, reconstructing them becomes really difficult and credibility suffers. It's also easy for you to keep track of your damages. If you have a different cost code, you can print an easy job cost report and tell really what your damages are. It helps you negotiate, and it helps you know really how much money you were out, and what it would take to make you whole. Under the total cost method, this is really the last resort. The total cost method is a calculation of what you bid versus what the job cost you. Courts and arbitrators are very skeptical of this method because it assumes your bid was perfect and that every single cost overrun was caused by the other parties. And those assumptions are rarely true, and they invite aggressive challenges. The total cost approach is very disfavored, so you don't want to be doing that. Modified total cost is a little bit better. It's a slight refinement. It addresses some of the weaknesses by deducting a certain amount of, I guess you would call, self-inflicted wounds, right? To account for the problems with the general total cost claim. But it still relies on a lot of judgment calls and assumptions, and you're almost always going to need an expert witness to testify to that. Most importantly, because one of the elements is you got to prove that the damages could not have been calculated in any other method, right? And for inefficiency and lost productivity claims, the measured mile approach is the best, but you can't possibly do a measured mile approach if you don't have the reliable baseline. And you get the reliable baseline by keeping really good project records. So it's got to be consistent, reliable documentation. So aim for the actual cost method or the measured mile approach. So very quick recap here. I'll do this in about 2 minutes. You want to be, doing staff training on these things. You want to make sure that you have clear workflows, standardized tools. I think the most important of this is assigning roles and responsibilities. You want that point person, all right, who's going to do all of this stuff and be responsible for it. They'll feel the pressure, they'll get it done. And then, of course, make sure that you are approaching your client with all the things we discussed today, understanding what their pressure points are, who they answer to, making it easy for them to pass a claim through or to accept a claim by following the contract. ADR quickly, mediation, I think is really helpful. I'm a big fan of mediation even before litigation. It helps you get free discovery and you can kind of figure out where the parties are before you head there. In arbitration, I really like it because I know people are skeptical of it because they say, oh, you don't have a judge, you can't appeal, that's fine. But in the construction industry, we're able to get arbitrators who know our business. And it really takes a lot of the guesswork in educating the judge or a jury, which is something that you rarely want to do in a construction case, out of the equation. Dispute resolution boards, those are really on larger projects. Most of the time they're non-binding. They're okay, but I haven't seen a ton of success with them because a lot of times the pressure isn't there to make one party accept an adverse position. Okay, so this slide really recaps our last, the overall thing. So I want to leave time for questions. I want to say thank you. If anyone has a question or wants to talk to me, here's my contact info. You can email me anytime, or I'm here right now just to listen to you if anyone has any thoughts.
Thank you, Jonathan. Yes, let's open up to the group. If anybody has any questions or experiences they'd like to share that maybe the group can learn from.
Oh, come on. I couldn't have aced it that good. I need to get something. Okay. TJ Rogers. Yes. Let's see. Thank you. Do you provide claims training for individual companies? Absolutely. We do that as part of our services. We will come in and talk to your project team and actually, bring them up to speed, do an in-person thing, go through the actual contract that you have questions about. And as I said, we can put together binders for you guys that it's easy to, there are templates. They have templates in there for the notices, have flow charts for claims. So yes, definitely. Anybody else? Oh, if you have I'm guessing if you have to notify a change order request per contract, you need to provide TIA costs, et cetera, and the deadline is tight and unrealistic. What do you do? What you do is, first of all, it ahead of time. You don't want to get surprised, right? So you are anticipating this kind of stuff. When you have a claim, remember, you don't start preparing when you get that issue arising or when that claim arises. You've thought about this at the beginning, right? So when that claim happens, that issue arises, you've got your team to call. You get the TIA in the best you can. You get your cost to date the best you can. You tell them that it's preliminary and that due to the short timeline of the contract, you are submitting this now. You reserve your right to supplement it and you reserve all your other rights under the contract. You let them know that the impact is still ongoing. You're still accruing damages. And then what you will do is you will update that from time to time. That's how I would say do that. Because you're right. I'm telling you, they're writing these contracts these days that are really hard to really fully comply with. And oftentimes that's what you got to do.
Okay, thank you. The thing is that, if I may, the thing is that in my company, sometimes when the contracts are very, very tight, the deadlines. So when we know that there is an event, there is very unlikely that we can get the impact or even a preliminary one within the time. So the idea here is like, okay, let's send a letter to preserve our rights, but we don't meet any of the rest of the contract requirements, such as content, as you said, provide the impact, whatever. We just send a notification saying, hey, we have this impact, but we don't know what's the real impact. So I guess that's absolutely it means nothing, right?
I'm sorry, could you repeat the last part?
Yeah, it means nothing that you just send a letter saying, hey, I preserve my rights because this happened, and per contract, I understand that this is a compensable event. If you don't submit absolutely anything else, the TIA, the cost, whatever, then it's like I mean, they could say, hey, you submit a notification, but you didn't meet any of the other requirements. So
Yeah,
they
I
can,
mean,
they can
that's
send you-
possible. That's possible, but you're better off doing as much as you can rather than
Okay.
doing nothing. You know, so
Yeah,
I would disagree that sending the letter itself means nothing. Because I think it does. And you can do your best to get a TIA in, right? You know, most construction companies at least have some scheduler in-house that can put together a rudimentary TIA, even if it's not perfect. But look, if you're on a bigger project, again, have that team set up, ready to go. It's like SEAL Team 6 for claims. Okay, someone that can, you know, you have your team set up. You've got your guy who writes notices. You've got your guy who's keeping all the documents. You know your schedule person, who that's going to be, whether they're inside or outside. And you tell your outside schedule consultant, you've got 5 days to come up with a TIA. Here's all my schedule updates. And have them do the best they can, you know, and then supplement it. But that's
you
what
can
I'm
always
saying.
send that worst
Do it
case
early.
scenario and then supplement it. Yeah.
Yeah,
Okay, that's
that's
a
what I
great
would
idea.
say.
Okay, thank you so much.
Sure, yeah. All right, I've got another question. In a situation where a prime contract contains flow down provisions to a subcontract and the GC or owner will not provide that prime contract, would you recommending negotiating out those flow down provisions? For example, liquidated damages, time to respond, that are based on the prime contract. My recommendation would be don't sign a subcontract until they give you a copy of the prime contract. I see it all the time. And while you're at it, get a copy of their payment and performance bonds. All right. Those are all things that you need to have, and that the process really slows down later where subs have a big claim and they want to get a copy of all those things. That's what I would do. You're not automatically relieved of your requirement to adhere to the prime contract. Oftentimes, when that argument is made, the prime contractor will say, the prime contract is available anytime they want to look at it in the project trailer. All right. And they will throw that back on you. Did you show up to the project trailer? Did you take it and go make a copy? You can't sit around on your hands and not take proactive measures. And if it really becomes a point of contention where they really refuse to do it, they don't keep a copy of it in the project trailer, they won't let you make a copy of it, then you need to start writing notice letters to that effect and putting them on notice, setting up a breach of contract for them. I mean, even if it's not written, they shall give you the contract. Breach of good faith and fair dealing, which is implied in every single contract in the state of Virginia. So that's what you do. You start turning the tables on them. Are you aware of or see any new claims processes or specifications coming out in the new VDOC spec book that may be an issue? That's a great question, David. Mea culpa, I haven't read it yet, but I certainly will. But I'll let you know. I mean, I know that in recent years, I'll just say over the last 10 years or so, they've made trying to get unabsorbed home office overhead recovery a lot more difficult to get. It's more in line with the federal system where you've got to have a complete shutdown to recover unabsorbed home office overhead, like federal. But before, whereas you just really have a delay and a substantial slowdown. But I will take a look at that. Thanks for pointing it out to me, David.
Hey, Jonathan, this is Billy.
Hey.
To add to that for David, VDOT is working with another association, VTCA, and through the CLC committee for the time impact analysis, the HOH, the GOH. So they're working through that now because it obviously hasn't been addressed for 25 plus years. So just letting everybody know.
Good. Are they releasing drafts of that stuff? Like, where can we go pick that up? Because I'd be really interested in seeing it.
Yeah, they're supplementing and sending out to the different associations as each section is being drafted.
Mhm.
So actually, I know you probably can grab that either through your all's association or reaching out to like the VA or VTCA. Tom would be able to get that for you pretty quickly. That particular section has not been drafted, finalized, drafted, and sent out for the associations to review yet, which is probably why you haven't seen it.
Yeah, okay, that makes sense. All right, well, Ashley, if you have anything like that, I would love to take a look at it if you could send it to me if you get your hands on one.
Just, that committee's been working with VDOT for like 2 years now, just on that section, as you probably can imagine.
Yeah. Yeah, I can. Definitely. Well, we're at 11:01. If there aren't any other questions, and I'm willing to stay here as long as it takes if you guys do have more questions, but I just want to thank everyone. I want to thank Ashley and Deborah for allowing me to make this presentation. I want to thank everyone who joined today. And thanks for listening to me talk for an hour about what I do for a living. I appreciate it. I got to nerd out a little bit. So thank you.
Wonderful. Thank you all for joining us, and hope everyone has a great day. Unless there's more questions. Mark, did you have a question?
No, I just want to say thank you. That was very useful and helpful. Appreciate your time.
You got it. Thank you.